The efficacy of Aboriginal title litigation in Canada is highly relevant to the outcome of this petition. The HTG are alleging that Canada is violating its property rights under the American Declaration. The HTG also claim a large area of land on Vancouver Island as its ancestral territory. They allege, the HTG, that it is not possible to obtain protection for these land rights in Canadian courts. Canada does not agree with these allegations. Canada defends the work of its independent courts. What the Commission needs to appreciate, an appreciation that can be gained by reading the very long decisions themselves, is why Aboriginal title litigants to date have been unable to prove Aboriginal title in the large areas that they claim as their ancestral territory. In the Roger William case, as one example, the inability of the plaintiff First Nation to prove its Aboriginal title related to the all-or-nothing approach that was taken. The court in that case concluded it could not issue a binding declaration recognizing Aboriginal title to the entire area claimed. The trial judge noted his sense that the claimants had Aboriginal title to some portion of the larger territory they claimed, but their case, because the claimants had taken this all-or-nothing approach, had not permitted him to determine from the approach they took the location or extent of their title. Canada asserts that a properly brought case with proof that adequately supports the claim will succeed in a Canadian court. Canada further asserts that neither the HTG nor its member First Nations have pursued their claims to Aboriginal title in a Canadian court. Canada maintains that it is no answer for the HTG on the merits of their claim before this petition to point to the inability of a few First Nations to succeed on their claims in a Canadian court. As Canada has noted in its submissions, the key to the allegations of violations of the American Declaration in this petition appears to be the allegations in respect to the right to property. In essence, the HTG alleges that Canada must demarcate the land contained in its claim to ancestral territory, and that it should have done so long ago. All other allegations of the petitioner flow from this central issue. Canada takes issue with all aspects of the petition. A key element of its defense, however, is the large gap between what the HTG claim is their property or ancestral territory on the one hand, and on the other hand, what in fact are the property rights of the HTG. In its submission dated October 12, 2011, Canada noted that the member First Nations have reserve lands, which are set aside for their sole use and benefit. In the time since Canada joined the Organization of American States, there have been no takings of land from the HTG or any of their member First Nations. The HTG assert a large portion of land taken up in the 1880s is their ancestral territory. This claim to ancestral territory exists as a basis for negotiations under the BC Treaty process, as it was identified by the HTG in their Statement of Intent, which is part of that process in the early stages. This claim has also been asserted before the Commission in this petition. This claim has never been proven. It has never been subjected to a determination by a domestic decision maker. As you can see from the smaller of the two maps that we handed out to you today, more than 75% of the land asserted by the HTG to be the ancestral territory of its member First Nations is also subject to claims asserted by 18 other First Nations. The map shows the overlapping claims within the BC Treaty process, and it demonstrates this fact that we are presenting today. While Canada acknowledges that the member First Nations of the HTG may have outstanding Aboriginal rights, including Aboriginal title rights, and Canada is seeking a resolution of these asserted claims in a negotiated settlement, Canada does not accept the scope of the HTG's claim to ancestral territory. Canada does not accept the so-called HTG Atlas can in any way be seen as proof of the extent of the ancestral territory of the HTG. The entire atlas is based on the boundaries drawn by the HTG for the purposes of negotiations. The entire atlas is therefore based on an unproven assertion. Moreover, it is not at all clear whether the details contained in the many maps in that atlas refer solely to the ancestors of the member First Nations of the HTG, or to the ancestors of the much larger Coast Salish indigenous people whose descendants make up many other First Nations on Vancouver Island in addition to the HTG. Moreover, on any reasonable review of the details in that atlas, there is no support in that atlas for the extent of the asserted claim. In conclusion, if I may, Canada notes that the petition brought by the Hulquminum Treaty Group raises issues that implicate all treaty negotiations within the BC treaty process, and indeed land claims in other parts of Canada potentially. Canada affirms the strong will of both the Government of British Columbia and the Canadian Government to continue striving with the HTG for a settlement of their claims through the BC treaty process. Canada remains optimistic that a comprehensive settlement can be achieved. Canada asks the Commission to find that Canada has not violated the rights of the HTG to property, to cultural rights, to freedom of religion, to equality, or due process as protected under the American Declaration. Thank you.
I'd like to thank both the petitioners and the government for their presentations. As the rapporteur on the rights of Indigenous peoples, you're probably not surprised I have a lot of questions. And some of these may actually be in the boxes of materials that are that I'm working my way through on this matter. We also have here the rapporteur for Canada. So let me begin and run through these quickly, and please feel free to submit answers in writing or tell me that it's in what you've already submitted if that's appropriate. My first question has to do with the status of the domestic treaties, as you call them, in Canadian law. Can they be changed by subsequent state or federal legislation, or are they of constitutional rank? In other words, what guarantees are there for the future if these domestic treaties are signed? And I say that as someone who's looked at the consequences of U.S. treaties with Native Americans. Secondly, a number of other common law jurisdictions have recently revised, or the courts have rethought some of the traditional doctrines about native title, and I think particularly of Australia and the Mabo decision. And I'm wondering whether the courts in Canada have similarly sort of re-looked at the idea of original acquisitions or early claims over Indigenous lands in the way that the court did in the Mabo decision. Thirdly, you made a mention that the government has not collected or tried to collect as yet any of the loans that have been made for this process, and I'm wondering if that is a policy of non-collection or if that is simply a deferral to a later time of making a decision on that part. In respect of the kinds of financial assistance that you mentioned, I think you said $54 million, do you view that as a form of reparations, or is that just simply a part of the government policy generally? So those are my questions. I'll ask the country rapporteur if he has any. Aren't you the country? No, you're the country rapporteur. Yes.
Sí, gracias.
Yes, thank you, President. I'm grateful for the respective presentations of both parties, and notwithstanding that I will be studying carefully all of the information that's been submitted in writing and that will be submitted in writing for the report of the merits in this matter, I'd like to take this occasion to put a couple of questions to each of the parties. And evidently, well, you could answer right now and or in written submissions subsequently. First, I ask the state, do you consider that there's a legal difference between the concept of private property and ancestral property of indigenous peoples? And in the event that you consider that there is a difference, would you consider that the ancestral lands of indigenous peoples in general, which may be alienated without consulting the peoples who live there, would continue to be ancestral lands which could prevail over those who hold private title to the land? And for the petitioners as well, I would ask you whether, as of the 1990s, what activities did you continue to carry out in the territory that you consider to be occupied by third parties, and with what frequency were such activities carried out? And while you already mentioned some aspects, how do you consider that the alienation of your presumably ancestral lands have impacted your cultural integrity? Thank you. Thank you very much. I am going to ask a series of questions, both to the state, which are for both the state and the petitioners. The first question is whether in Canada the law recognizes property rights of indigenous peoples to their ancestral territories as a category of its own, or is it considered to be some other form of private property? Second question is, I'd ask that you inform us as to what actions and procedures exist in the Canadian judicial system to resolve land claims by indigenous peoples and economic reparations. I would also ask the petitioners whether such actions have been brought within the judicial system and whether you consider that such actions are adequate and suitable for respecting your rights. Thank you very much.
I give an opportunity to both sides to reply. I'd just like to make an offer. Next week, the Commission will preside over the signing of a friendly settlement on a major indigenous land claim involving another of the member states. And we expect that will be followed by yet another. So it is something that we are very interested in facilitating. If there's at any point in the discussions between the group and the government that you think that the Commission could play a constructive role, we certainly offer ourselves to participate in the negotiation process to try to facilitate some resolution of this. I think our experience thus far has been, at least in this past year and a half, has been very positive in that regard. So with that in mind, we have about 10 minutes, so I'll give 5 minutes to the petitioners and 5 minutes to the government.
Thank you, and thank you,